Did you forget to report your work injury within 30 days? You're not alone, and your case might not be over, but you need to act now. Here's what the law actually says and how to protect yourself. The rule: in Virginia, you have 30 days to report a work injury to your employer in writing. Miss that deadline, and the insurance company can raise a notice defense, arguing that it couldn't properly investigate because you reported the injury late. If they prove your late reporting prejudiced their investigation, you could lose all your benefits. No medical care, no wage loss payments, no settlement, nothing. That's why employers and adjusters hammer this point when they deny claims. But there's hope. The Workers' Comp Commission and Virginia courts interpret the Workers' Compensation Act with a humane purpose. That means there are legitimate ways to overcome late notice. The most common? Actual knowledge. If your supervisor, foreman, or anyone in management or HR knew about your injury within 30 days, even if you only told them verbally, that can satisfy the notice requirement. The Virginia Supreme Court has held that oral notice to a supervisor counts. Same thing if the company owner or an executive witnessed your accident. They can't pretend they didn't know it happened to you just because you didn't fill out paperwork. And there are other situations where we've successfully defeated notice defenses. If you called your supervisor but couldn't reach them, so you told their secretary and followed up with a voicemail, that may work. If you contact the insurance adjuster directly because you had a prior workers' comp claim with the company, that could also count. If you told your employer about your injury and dropped off medical records describing the incident, even without formal paperwork, that can satisfy the notice requirement. And here's an important one. If your injury seemed minor at first, but a medical diagnosis later showed it was more serious, Virginia law may give you more leeway on the reporting deadline. So what do you do if you're past 30 days as you watch this video? First, report it in writing immediately, even if it's late. Include every detail: the date, time, location, what happened, who witnessed it, who you told about it, and when. Next, document any conversations you have with supervisors, coworkers, or HR about the injury, even casual mentions. Get witness statements if possible. Third, don't try to handle this situation alone. Insurance companies love notice defenses because they're easy wins if you don't know how to fight them and prove actual notice. So the bottom line, late notice doesn't automatically kill your claim, but it does make it harder. The sooner you act, the better your chances. Call us at 804-251-1620 for help, or visit my website, cpollardlaw.com, for more information about the workers' comp process. Best of luck with your health and your claim, and don't forget to click the subscribe button. Thank you.